Sarah, good morning to you. Thanks
Morning,
for
Wally.
making the time to come
Always
and speak to
lovely
us
to be
here.
here.
The opponents of this bill, as you have already heard me say, they're terming it the Internet Censorship Bill. Why is it courting controversy?
So I think before we get into that, it's worth just discussing what the intention of the amendment bill is. So the original Films and Publications Act was designed to regulate on content that we view and to mostly protect prohibited content, classified content that's perhaps age restricted or violent in any way. And the amendment bill, which was first introduced into the NA as far back as 2015, was the real intention was there to accommodate how we now publish content on the internet. It didn't account for uploading content onto social media and the various different ways we, publish content digitally now. But I think one of the biggest criticisms of the bill is, in terms of the Act, and this remains, you have to classify content before you published it. So it had to be classified in terms of its age, whether it's violent content. But that was easy when it was just pertaining to videos. They would go to the Films and Publication Board before you could put the video to market or distribute it in any kind of commercial way. But now the way that we publish our content has changed so dramatically. So this requirement of pre-classification is not necessarily that practical when it comes to online content.
What is so different now?
Well, we need to look at the way we communicate now and the way we publish content now. So, for example, when I upload a video onto social media, Facebook, does that need to be pre-classified? The way that the Act now has defined film actually includes our own video content on social media. It's the drafting, one of the biggest criticisms of the bill is that there are a lot of ambiguities in the drafting. A lot of the definitions are extremely vague. Another big criticism it has is the live streaming component. So a lot of content we view now is live streamed.
You can't predict
how do you classify live stream content because you're creating it as you publish it? Does that mean it's illegal in terms of the bill? These are some of the questions that critics have really grappled with.
So what exactly is being encouraged here? Self-censorship. If, for example, I'm going to make a video, before I post it online, I need to know exactly or familiarize myself with the rules that if I do this, if I post this video and in its current form, perhaps it might offend another person.
Well, I think the underlying intention is absolutely a greater awareness of the nature of content before it's published. I think one of the benefits, one of the good aspects of the bill, some of the new introductions we've seen, is certainly the revenge pornography provision. Now, in terms of the Bill Now Act, any intentional distribution of private content without the consent of the person depicted in the content is actually a criminal offence. Yeah. That provision, too, has some flaws in terms of the way it's drafted, but certainly in terms of some of the benefits or the new provisions that we didn't see previously in the original Act, that's certainly something positive.
Child pornography, for example, as well.
Absolutely.
That's something that's getting a mention, and some people sitting at home listening to you and I will probably ask the question, so what's so bad about regulating the distribution of child porn, revenge porn, as you've just mentioned? What is wrong with that?
The intention is absolutely applauded and very much necessary. I mean, we see in our office daily a proliferation of revenge pornography cases, child pornography cases. It's absolutely on the rise. So absolutely regulating it and making it a criminal offence is totally necessary and very welcome. Our concern is the way the Act now is drafted. So as I said before, as with a lot of the Act, there are a lot of ambiguities. So one of them, for example, is the definition of what exactly is private content. The final wording of private, as it's defined in the Act, is that it's not intended to be viewed by others. But does that mean if I send one person who I'm in a relationship with a private video when I'm in a relationship, I intended him to see it, but we then end the relationship and he distributes it, would that not fall under the Act? Would I not be able to rely on the Act then to institute criminal proceedings if he distributes it? These are some of the questions we're asking with the way the Act is currently, is drafted finally. And a lot of people who were involved in making submissions around the Act, I know Emma from our office made a number of submissions to Parliament, as did many people, were hoping that the final wording would be would not have as many ambiguities, but unfortunately, this is the version that was signed off.
I foresee a challenge.
Absolutely.
All right, thank you very much. That's Sarah Hoffman. She is a social media law expert.